Hi friends, welcome back to my channel. Today we're going to discuss criminal conspiracy, which is in BNS section 61. This is the topic that we are going to discuss today. If you are following my channel, you won't be require much books to refer because I already have referred much books and taken important content and made this video. So criminal conspiracy, definition and types and punishments and case laws is what mainly we are discussing in this session. And before getting into any topic that you are preparing, you'll have to have your own set of questions. What is this all about, and when, how, who it is related, and where it has happened, and when, why, and to whom. All those things you should be having a set of questions and try to answer for all these questions, so it is very easy for you to remember all the content at one stretch. And definition and criminal conspiracy. Criminal conspiracy is not at all a new topic. BNS to BNS, because it was already there in the Indian Penal Code, that is IPC. Now very recently they have renamed it and certain sections have been aligned and new sections has been added. So that is we will be discussing in upcoming classes. Today we will only discuss what is criminal conspiracy and related case laws, right? So when two or more person agree to do or cause to do something illegal act or an act which is not illegal by legal means. Illegal means that if you are doing any criminal offenses against people or hurting people, all this causes as constituted as a criminal conspiracy, a mere agreement between two person or two or more people. Okay, so one person has an intent to kill or rob or something. You have a contract with another person, right? So that is when it becomes a criminal conspiracy. Two or more people involving into the criminal offenses. Essentials of the criminal conspiracy is two person has to have an agreement that there is an existing agreement between two or more person committing an illegal act and intended to achieve an unlawful object. It is not a lawful object, it's an unlawful object, which is very, very important. So overt act, which is in cases of overt act, must be committed in furtherance of conspiracy. Actually, bare act does not have the types of conspiracy. For your better understanding, what I have done is I've just segregated certain cases and I have made a types. It is going to be very much useful for you guys. Conspiracy to commit a crime, an agreement to commit a specific offense such as the theft, murder, or fraud. It all comes under the criminal thing. And conspiracy against the state, if you are doing anything against the state, like treason and act of terrorism, so all comes under the conspiracy against the state. And conspiracy against the civil matters, if you are doing a defraud or causing non-criminal or harsh in non-criminal matters. Next is chain conspiracy. Chain conspiracy is like contributing the larger, or it is always in a link. You have more contract people and you are involving in a series of agreement among people, which is called as a chain conspiracy. Wheel conspiracy, involving in a central figures and coordinating multiple conspiracy with the preparation of group. Okay, punishment for criminal conspiracy depends on the amount of the grievances, how serious about the conspiracy is matters. So if the conspiracy related to serious offense, punishable with the same punishment as an offense conspired. For example, conspiration to commit murder can lead to life imprisonment or the death penalty. If the conspiracy does not relate to serious offense, then the punishment would end up only for 6 months to some amount of fine, or sometimes both will be given. So when it comes to case laws and illustrations, I have good collections of all the conspiracies. So I already said that Bayer Act does not have segregated types of conspiracy, just a 61, 62, 63 talk, 61 and 62. Only these two sections talks about the conspiracy, but I have given the elaborate case laws and explanations that will really help you while writing an exam. One or two cases if you can mention also, that will really fetch you good marks. So general conspiracy, in general conspiracy I have in a small illustrations what happens if it is a bank robbery comes under the general conspiracy. A and B plan to rob a bank. C provides the tools and the agreement itself is enough to establish a conspiracy. So it is just an illustration. So there is a case laws, Malkay versus the Quinn. In this case law, what happened? A plan committed to treason. It was held in the agreement to commit an illegal act. It is actually what happened in this criminal conspiracy. Macaulay was an accused to conspiring to kill the Cohen. Okay, he conspired, but he didn't commit the. He didn't kill her. The case questioned whether the conspiracy itself is not an offense without an actual crime being committed. So the judgment held that conspiracy is an offense even if it intended to criminal crime in is not executed. So the argument was that murder didn't happen, how can the person can be accused? But then judgment held that if you're not committed the criminal act or crime, but it's still intended to it's not necessary to execute. That is the thing, and preceded criminal law. Next one is conspiracy to commit murder. In this conspiracy commit murder case law, if you wanted to remember only illustrations, A and B agrees to kill C, and A purchases weapon. Even if no murder occurs, A and B are guilty of the conspiracy. Okay, if you wanted to write only illustration, you can write this, but if you write a case law, that will give you more marks. So one of the remarkable cases, Rajiv Gandhi assassination case versus Nalini state of Madras in 1999. That is the fact involves the conspiracy of assassinate the Indian Prime Minister. The court held that all the participants are guilty and conspiracy. Fact and background of the case. In this case, the incident happened in 1991, May 21. It happened in Sri Perumbudur. As you all know, our honorable Prime Minister was being assassinated in this. Who was killed or who plot this conspiracy is claimed to be LTT, that is Liberation Tiger of Tamilam, and the suicide bomb was Danu. Okay, the assassination was LTT retaliation against Indian involvement in the Sri Lanka, and civil war held there. So that was the reason for Rajiv Gandhi and other 14 people were Rajiv Gandhi was killed and other 14 people were injured. Okay, key accused was the Nalini, and they have given life actually for Nalini, and Murugan was the prime accused in this. Santanam and Per Arivalan also were among them, and they were charged for terrorist and destructive activities. For them, they have given the death penalty. Actually 26 were accused, and for all of them death penalty was given. Later, due to some thing, you can go through this case laws, because it was involving lot of informations, you can always go through. Later it was given a life imprisonment for them. Okay, conspiracy to defraud. The conspiracy to defraud, A and B cheat C out of property through the false document. This you can write it as an illustration. If you wanted to write a case law, Suresh Chandra Bahari versus State of Bihar. In this case, the accused conspired to fraudulently transfer property. What he did was, Suresh Chandra was convicted to murdering his wife and two daughters in Bihar. In this case involves circumstantial evidence. There were no eyewitness. So what happened? The court held that the death penalty based on the strong circumstances evidence. If they do not have an eyewitness, still they consider circumstance evidence and given the death penalty. So this comes under the conspiracy to defraud. Next case is terrorism related to conspiracy. The terrorism related conspiracy, like planting bombs in public places and spread terrorism, all these things. So in this case is Afzal Guru and state of Indian thing. It is 2005. This accused conspiracy attack on Indian Parliament, and the court convicted the conspiracy under the Terrorism Act. Afzal Guru was convicted in 2021 an Indian Parliament attack and carried out by terrorists and linked to Jahi Muhammad. I'm so sorry for wrongly pronouncing this name. And so death penalty was given. Refused to death, and 9 security persons, staff members, all that happened. But for him, there were a death penalty was given to him for his mercy petitions was rejected by the President of India. Next was conspiracy in organized crime. So organized crime is smuggling, narcotics, and other country, all this involving the conspiracy in organization crime. So we do have a separate topic, all these things like abetment and war against it, and all these things. There also you can write the same case laws. So in this state of Maharashtra versus Somnath Thapa, this was the major case. In this case, what happened, the accused involved in the drug trafficking conspiracy, the court elaborated to principle of conspiracy. Background of this case was was related to terrorism and national security, and meaning the criminal conspiracy under BNS is 61, IPC it is 120B. So Supreme Court held that mere agreement to commit a crime is sufficient to prove the conspiracy. Next is political conspiracy. In this conspiracy, we can understand that overthrow of the government by unlawful means. So Indira Gandhi assassination case of Kehar Singh, state of 1998. In this case, what happened is involved conspiracy assassinate the prime minister. The court convicted the conspiracy involved in the plot. In this case, as you all know, the Prime Minister of India was assassinated on October 31, 1984, and by our own bodyguard, Ben Singh and Satwant Singh. Reason was that retaliation for the Operation Blue Star, where the Indian Army stormed the Golden Temple in Amritsar and removed Sikh militant, leading to the significant casualties and damages. Accused Kedar Singh was accused of conspiring the assassins and instincting them. He was charged under Section 120B. So that was the case law. As you all know, the Supreme Court held that they given the death penalty to Satwant Singh and Kehar Singh, and the court held that Kehar Singh had indoctrinated Behan Singh with a extremist ideology, meaning he abetted him an extremist ideology to kill her. That is considered as a conspiracy, and execution both were hanged on January 6, 1989 at Tihar jail. Now, why it is matter is, in this case, President for the criminal conspiracy and instigation as a punishable offense in cases of political assassination. Next one is chain conspiracy. In this chain conspiracy, if you wanted to write only illustrations, the A plan with B procure illegal arms, and B coordinated with C and distributed them. So if you want to study the case law is R.V. Shehai, 1994. The court discussed how conspirator in chain conspiracy can be linked to the common goal. So if you have a common goal, if you are not committed, still you are considered as a chain conspiracy. Right. So in this case, the incidents took place in New Zealand. Okay, it didn't happen here. And Hay Group and clothing import and export company was accused fraudulently representing the value of imported goods, and customs authority accused the company and its director were charged with a conspiracy of defraud, and legal issues where the case involved around whether the conspiracy to commit an impossible act under the invoicing goods and still be crime. So judgment was that the New Zealand court have upheld the rule that the conspiracy to commit an impossible act and is still punishable. The accused were found guilty, setting legal precedent, and even an act is legally or factually impossible, conspiracy to commit remain a crime. Why it does matter? This case clarified the conspiracy law and emphasized the intended and agreement to commit fraud and punishable regarding to the feasibility. Conspiracy to commit theft. So we have two. One is illustrations. A and B agrees to steal from a warehouse. So if you can only write the illustration, you may not get enough marks. So we'll also understand what is case law about K.V. Raghavan versus State of Kerala 1974. This conspiracy committed to theft was proven with the circumstance evidence. The fact and background of the case was Raghavan, a government official in Kerala, was accused corruptions and misuses of power under the Prevention of Corruptions Act 1947. He allegedly accepted bribes in exchanging the favor certain contractors in public work projects. So he has taken a bribe. That is the reason he was accused. So it was what was a legal issue in this? The case examined whether his actions constituted misconduct under the criminal law. Judgment, according to judgment, what was that? Supreme Court held that he is convicted and confirming that he had abused his official position for the personal gain. Right, so he was also sentenced to imprisonment to fine it under the Preventive of Corruptions Act. And why it is important? This case reinforced India's anti-corruption laws and emphasized strict punishment for public officials engaging in bribery. Next is conspiracy to commit crime. Cybercrime, and cybercrime is all about that it is an internet through internet or social media. If you commit any crime, that comes under the cybercrime. So illustration: A and B conspired to hack a government database for the personal gain. That is called cybercrime conspiracy. So case law, Shreyas Singhal versus Union of India 2015. In this case, the court elaborated the internet-related conspiracy and the applications of the law. So fact and background of this case: 2012, the girls were arrested posting a comments on Facebook criticizing the struck down of Mumbai after the death of politicians Bal Thackeray. So accused, what was the accused were made under 66A, the IT Act 2000 was criminalized the posting offenses of content online. Legal challenges where Shreya Singhal was